Employment agreements in Arizona. Real estate employment agreements are the foundation of the relationship between real estate licensees and their clients, both buyers and sellers. They define representation, compensation, duties, and the conditions under which a broker earns a commission. Arizona law requires that all employment agreements be in writing, contain specific disclosures, and comply with statutory and case law to ensure clarity, fairness, and enforceability. Buyer employment agreements. A buyer employment agreement establishes the legal relationship between a buyer and a real estate broker. It outlines the scope of representation, compensation terms, and the broker's fiduciary duties. Under ARS, Paragraph 32-215102D, the law distinguishes compensation from representation, meaning payment from a party, buyer or seller, does not automatically determine who the agent represents. A buyer's broker may be compensated by the seller, listing broker, or buyer directly, but representation is based solely on the written employment agreement, not on who pays the commission. The core requirements for all employment agreements are found in ARS, Paragraph 32-2151.02, and ARS 44501, 4452, and 44503, Arizona's Statute of Frauds provisions. These statutes mandate that any agreement for real estate compensation, whether for the sale, lease, or purchase of property, must be in writing and signed by all parties to be enforceable. Clearly specify the amount or method of compensation. Identify the duration of the agreement. Disclose the parties represented and the broker's license number. Be delivered to all parties upon signing. These statutes protect both the public and the brokerage by preventing disputes over commissions or misunderstandings about representation. Listing employment agreements. A listing agreement is the employment contract between a property owner, seller or lessor, and a broker to market and sell or lease property. All listings must meet the same statutory standards outlined in ARS, Paragraph 32-2151.2, and ARS, Paragraph 44-501 through 44-503, requiring the agreement to be in writing, signed, and delivered to the client, and to specify compensation terms and expiration dates. Exclusive listings. In an exclusive listing, the broker is given the exclusive right to market the property for a set period. The seller cannot employ another broker during that time without breaching the agreement. In Mealy v. Orlick, 1978, the Arizona Supreme Court held that a listing broker earns a commission when they procure a ready, willing, and able buyer, even if the seller later refuses to complete the sale, because the broker has fulfilled their contractual duty. Similarly, Larson, Hagstrom and Associates, Inkerver v. Jeffries, 1985, affirmed that a broker may still be entitled to a commission if a seller unilaterally withdraws the property from the market during an active exclusive listing period. The ruling reinforces that sellers cannot avoid paying commissions simply by revoking a listing after a broker has begun performance under a valid contract. Open listings. An open listing allows multiple brokers to market the same property, but only the broker who is the procuring cause of the sale earns the commission. In Demand Issues Foley, 1970, the Arizona Court of Appeals defined procuring cause as being the agent whose efforts directly result in a sale to a ready, willing, and able buyer on the seller's terms. The Arizona Supreme Court, in Nash v. Gore, 1963, ruled that if a seller secures a buyer without the assistance of any broker under an open listing, the seller owes no commission. This underscores that brokers only earn compensation when their actions are the direct cause of the sale. The concept of procuring cause was further defined in Clark v. Ellsworth, 1947, and Mohammed v. Robbins, 1975, establishing that the broker's efforts must initiate a continuous and unbroken chain of events leading to the completed transaction. If another broker or the seller finalizes the deal independently, the original broker is not entitled to commission. Net listings. Net listings are legal but strongly discouraged in Arizona due to potential conflicts of interest. In a net listing, the seller sets a minimum acceptable price for the property, and the broker keeps any amount received above that price as commission. For example, if the seller wants $400,000 and the broker sells for $425,000, the broker keeps $25,000. Although allowed under Arizona law, this arrangement can create ethical risks because it may incentivize brokers to prioritize their own profit over the seller's best interest. Therefore, licensees must ensure full disclosure and fairness if entering into such agreements. Collectively, these statutes and cases emphasize that employment agreements must be written, transparent, and compliant with Arizona law to ensure the protection of both clients and brokers. They also reinforce that compensation must be earned through lawful performance and not through unauthorized or misleading conduct.